This last part of the unit, I'd like to look at China and Japan. In China, some data security and privacy laws have been enacted, but it's difficult to judge how aggressively these will be enforced. China does not have government regulators focused on enforcing these laws. In 2012, the Standing Committee of the National People's Congress issued the Decision on Strengthening Network Information Protection, which imposed new privacy obligations on some companies, but it's unclear how broadly the law was meant to be enforced. Internet service providers and others that collect personal data were included under this particular law. Companies must abide by principles of legality, legitimacy, and necessity. A 2015 report, European privacy experts criticized the scope of the Chinese privacy laws. It was internet only. Enforcement mechanism, there was none. Basic data subject rights, there were none. And principle setting, not as complete as the EU model. There were 2013 amendments to the Chinese law, which reiterated that companies will abide by the principles of legality, propriety, and necessity, but must explicitly state why the means and scope of data are being collected and obtain consent from the data subject. They must keep collected data confidential and must not disclose, sell, or illegally provide that data to others. They need to implement technical measures to protect consumers' personal information from being disclosed or lost, immediately adopt remedial actions if personal data are lost or disclosed, and must not send commercial information to customers without their consent. Still, there's some concern over how aggressively these laws would be enforced. 2013, the Ministry of Industry and Information Technology provided more detail on security and privacy in a law called Information Security Industry Guidelines for Personal Information Protection on Public and Commercial Service Information Systems. It talked about personal data, and it's computer data handled in computer systems related to a specific natural person, which can be independently or in combination with other data information, identify a specific person. And it laid out 8 principles: clear purpose, least sufficient use, open notification, individual consent, a quality guarantee, a security guarantee, honest implementation, and clear responsibilities. In Japan, privacy stems largely from the 2003 Act on the Protection of Personal Information, the APPI. Similar to the comprehensive EU approach on data regulation, however, it's more stringent than the US sectoral approach. The differences, though, from the EU is Japan law does not require additional restrictions on sensitive data and does not differentiate between data controllers and data processors. It does not require other countries' laws to be adequate before allowing foreign data transfers. And the definition of personal data is very broad, and it suggests that personal data protection is a human right. The key duty imposed on businesses that handle Japanese residents' data are the purpose of the utilization. You must specify the purpose, and you cannot unreasonably change the scope of the purpose, and you must obtain prior consent before collecting the data. Proper acquisition. You may not use deception to acquire personal information, and notice at the time of acquisition you must notify the user of the purpose of the data. It does not apply if necessary to comply with law enforcement. Accuracy. You must endeavor to maintain accurate and up-to-date personal data. Security controls. The business operators need to take necessary and proper measures to protect data to prevent leakage, loss, and damage, but it doesn't specify what those particular safeguards are that have to be implemented. Again, you could use a framework to guide you in that process. Employee supervision. Ensure that employees handle data properly. Transfers to third parties. You may not provide personal data to third parties without prior consent. The only exceptions to this is if the transfer is based on laws or regulations, or the transfer is necessary to protect individuals or property, and the consent would be difficult to obtain. Public health or child welfare and consent difficult to obtain, and necessary to cooperate with the government. Public privacy notice must post a publicly accessible document containing a number of the name of the business officer responsible for handling personal information, the purpose of the data, and procedures for handling requests for personal information from the data subjects. Business operators must generally correct, add, or delete personal information at the request of the data subject. 2017, Japan implemented a Privacy Protection Commission to enforce Japan's privacy laws.